Rich Rising. I know no one is on the live yet, but y'all will be able to see this in the replay. Um, so this morning I want to talk to you guys about two very, very important laws that many people are not aware of. In school, we really never get any exposure to, and that has become a problem. So I want to talk to you guys about these two laws, and I'm gonna start when I get a. I'm gonna try to wait till I see a few people get on here. I don't want to go too fast. All right. So the first law is the Securities Act of 1933, and this is going to be my book reference. Y'all, full disclosure, I'm sitting in my garage right now. I'm just enjoying the breeze. But this is a securities regulations book. Y'all can look this up. This is the third edition. All right, so the Truth in Securities Law, aka the Securities Act of 1933, is a law that has two basic objectives. One is to provide investors with material, financial, and other information concerning securities offered for public sale. And two is to prohibit misrepresentation, deceit, and other fraudulent acts and practices in the sale of securities generally. So, back in 1933, they came up with a law to protect anyone who was investing in securities, whether you were selling them, whether you were buying them. The Securities Act of 1933 was created to help protect you, and it also was to help prohibit misrepresentation, deceit, and fraudulent acts in the sale of securities because they knew way back then the bankers were up to something. Like, if we just gonna be real, in 1933, that's when they took all the gold. 1935, that was when they introduced the Social Security Act. So all of these things happened because of this Securities Act of 1933. Is registered, it has to be, or each security that is sold, it has to be registered. So registration of security says the first applies to securities offered for public sale by an issuing company or any person in a control relationship to that company. Before the public offering of such securities, a registration statement must be filed with the commission by issuer, setting forth the required information. When the statement has become effective, the securities may be sold. The purpose of registration is to provide disclosures of financial and other information on the base of which investors may be furnished and may appraise the merit of the securities. I done highlighted through a lot of this stuff. To that end, investors must be furnished with a prospectus, which is a selling circular containing the data set forth in the registration statement to enable them to evaluate the securities and make an informed and discriminating investment decision. So the whole reason why the securities have to be registered is so that the people who are investing in them can have an informed um, can have some informed information. A lot of times we sell securities and don't even realize we selling them. Like when you sign a contract for a home or a car, you're basically selling a security for that property. That security is going to be sold to a bank. The bank is probably going to sell it to another bank. Do we have any? I see we have a few people on the live right now. Do we have any homeowners on the live? Put one in the comments if you are a homeowner. Or maybe if you have like a car that's financed or something. For sure, if you have one of them, you've created a security. If you have, maybe you leased an apartment, that's a security. If you paid a security deposit, that's security. If you have utilities with your local utility company, like the water, the lights, those are securities. You created a security when you submitted the application. When they opened up the account was an open-ended credit plan. So anyway, back to Securities Act of 1933. Let's talk about exemptions from registration. So the registration requirement applies to securities of both domestic and foreign private issuers, as well as the securities of foreign governments and their instrumentalities. So everybody's securities have to be registered, even the ones that you have through the registrar's office, like your birth certificate, that's a security, is registered with the Securities and Exchange Commission because of the Securities Act of 1933. Everybody on here watching has at least has a birth certificate. If y'all don't have nothing else, y'all have a birth certificate, right? Most of y'all. All right, so let's see, there are two exemptions from the registration requirement. Amongst these are, one is a private offering to a limited number of persons or institutions who have access to that kind of information that the registration would disclose. And two is offerings restricted to the residents of the state in which issuing company is organized or doing business. The purpose of registration. So the registration of securities does not insure investors against a loss in their purchases. The registration of securities is basically so you can have a full disclosure of what the company's legal standing. They tell you exactly how they make the money from these securities. So if you, let's just say you signed this is not legal advice, by the way, YouTube, this is not legal advice, this is for educational purposes only. But if you were to go and sign a security for a house or sign a security for a car, then there is a prospectus document that's registered with the SEC that actually says what they're doing with your security. So even if you don't know, this is not common knowledge to you, you could go find that prospectus document, read it, and then find out what they're doing with your security. If y'all were on the live yesterday, I kind of showed y'all one of those. If not, you could just go to sec.gov and look for yourself. Anyway, back to the registration document. So the purpose of registration is to provide disclosures of these and other important facts so investors may make a realistic appraisal of the merit of the securities and thus exercise an informed judgment in determining whether to purchase them. In proper disclosures, the commission cannot deny registration or otherwise bar the securities from public sale, whether or not the price or other terms of the securities are fair, or the issuing company offers reasonable prospects of success. So this could basically be a company this means that this could be a company that is not doing well. They just trying to get off these securities so they could go, close down and move it along to another company. The SEC doesn't care as long as they put that information out there. Then the information in the prospectus documents are not always they're not always true. I say that because there's a statement. I'm gonna see if I can find one right quick. I say that because there's a statement on the actual prospectus document that says the SEC cannot be held liable. All right, so here's one. Okay. So this is a prospectus document for Verizon. I simply went to Verizon's website. Y'all see that it says prospectus, right? So when I clicked that, it took me to sec.gov. So this is a prospectus document that tells. Wait, let me wipe my camera. My camera looks a little greasy. I'm sorry, y'all. All right, so this document basically tells what they're doing with the notes, how they're over collateralizing them, who they're using to securitize. It basically tells everything. But I wanted to bring y'all's attention to this statement that's in bold right here. It says neither the U.S. Securities and Exchange Commission nor any state has approved or disapproved of these securities or determined that this prospectus is accurate or complete. Any representation to the contrary is a criminal offense. Now, my whole question would be, if y'all the SEC and y'all regulating these documents, this statement tells me that everything in this statement could be a lie, or it could be unfair, or it could violate the law, or it could do whatever. But as long as they said it in the prospectus document, it's valid. Y'all hearing what I'm saying? I see that I have a few people in the chat, but I'm not seeing no comments. Y'all understand? Y'all grasping this? Or y'all totally lost? Are y'all grasping it or y'all lost? I'm basically telling you guys to go, whatever companies you're dealing with, go look in their prospectus document. Anybody on here have Verizon? For instance, since I showed y'all Verizon's prospectus, a lot of people that have Verizon Wireless don't even know that that's not their real name. It's not. Their name is Cellco Partnership. They're doing business as Verizon Wireless. So I'll show y'all that. That's literally on the first line. Right here. It says Cellco Partnership. DBA Verizon Wireless. So if you were to have a real issue with your phone company, you couldn't even sue Verizon Wireless because it's not even a real company. This is the company. I found that out because I just sued them. So this is the reason why I sued. This statement goes on to say the notes are secured by The notes are secured by all of the issuing entities' assets consisting primarily of an interest in a revolving pool of device payment agreements originated by Cellco Partnership doing business as Verizon Wireless and certain other affiliations of Verizon Communications. So basically, you got Verizon, Lisa. Lisa, do you have a phone that is do you have a phone that is like finance? Like, do you have one of those new iPhones that they may have let you put on a plan to where they add $20 to your bill or whatever monthly? I'm not trying to get in your business, but I'm just trying to make an example. So if you were, let's just say you were in that situation. Say you went and got an iPhone 15 and they said, oh, it's $1,000, but we're gonna break the $1,000 up into $20 increments and we're gonna add it to your bill. So when for them to do that, you had to sign what was a contract, right? You would have had to sign a contract. They have a device payment agreement that if you just go to Verizon website and type in device, she said, yes, I have an iPhone for perfect. So let me show you this. You remember when you got your phone? Remember they had, did you go in the store or did you do it like online? Because I did mine online. And I didn't go in the store, but when I did it online, I talked to somebody over the phone at the same time and I was asking them, is this a security? Is this going to be, I already knew what they were going to do with it, but I just wanted to see if they were aware of what they were doing with it. And the man was like, no, this is just like basically like an IOU. So that means that there was never a true meeting of the minds because Verizon, let me see something. Let me just Google a device payment plan right quick. Okay. So this is what you sign. This is what you sign. So on this document, it says retail installment contract, and it says retail installment obligation, security agreement, subject to state regulations. All right. It said nothing about federal regulations because they breaking a lot of them. With that being said, they have a buyer's name and the seller's information is up here. Verizon Wireless, basically. All right. So it's a buyer and a seller. And then you see them say, you, meaning the buyer, named above, agree to pay the seller the total sales price of blah, blah, blah. It does not say that they agree to give you anything. So Verizon never said Verizon agrees to pay you nothing. You start off by saying you agree to pay. So first of all, this is a unilateral contract. This contract it's a one-sided contract. There is no bargain. You're basically telling Verizon, I agree to pay you something. Verizon never said, I agree to give you a phone. Even though it says seller and buyer, that's ambiguous. That could mean anything. They could be selling you anything. You could be buying anything. Even though it says description of goods, it still never says a promise by Verizon. So if you were to go to court, the only person that wins in this contract is Verizon because it's one-sided. So it starts off by saying you agree to pay this. Then there's money involved, which that's a violation of truth in lending. But there's a statement here that says you grant the seller creditor a security interest in the device, and that's why they get to continue to collect those monthly payments from you, even though they're going to securitize this document, and this is going to pay for it. The actual cash value of this document is going to be whatever the total is. So if it's 1,500, it's going to be 1,500. They're going to actually get this cashed and get the $1,500, and then you're going to be paying them back. So each security gets interest paid to that security monthly. So the interest is the bill that they're sending you. And that bill is going to go into an interest-bearing checking account that's held at a bank on your behalf. So I could go ahead and tell you that the bank is U.S. Bank for this one just because Like I said, I've dealt with them already. But that's also on this. That's also on this. If you see U.S. Bank right there on the right hand side, that's also on this prospectus document. Something else I want to show y'all before I get back to what I was reading. It's a chart. Here we go. So this breaks down the transaction structure for Verizon. Again, I told y'all their name is Celco. It's not really Verizon, but when they originate these one-sided agreements, they sell them. So that's how the money is made. They are selling these agreements. I don't know if this is focused, but if y'all can see that. The agreements are sold from Verizon to Verizon Asset-Backed Securities number 2 LLC, and then it's sold from them to Verizon Master Trust. Those are two different entities that are going to securitize that same document. And then it's going to go over here and be grouped. And that group is going to pay the investors back. The payments that go to that group are going to pay the investors back. All of that is explained in this prospectus document. The process that they do it under also is shown in a chart, in this chart right here. So like if I was to get closer on this, I don't know why this camera is not focusing. But this talks about master collateral agreement, U.S. Bank Trust Company, National Association, appointed master collateral agent. The trust designates device payment plan agreements to groups and pledges such device payment plan agreements to a master collateral agent to secure the credit extensions of each series of such group. The trust allocates collections to each Group 1 series and the transfers interest. The trust applies payments on the receivables allocations to Series 2024-1 and other series available. Which is wild because this is not something that they tell you, but this is a chart of how they do what they do. This prospectus is very, very, very detailed. Lisa, I would say go run to sec.gov and get this. Or you could go just Google Verizon prospectus, depending on what month and what year you actually purchase your document. It's going to tell you which prospectus you need to read, but they all basically have the same information. It's just going to be different numbers. All right, so I just want to give y'all that example of when we talking about securities, like anything could be a security. Anything that you're paying a security deposit for, because that security deposit has to go in an account, and that account has to incur interest. That account is going to incur interest because it's holding a deposit. Do I understand that money just sitting somewhere ages, it incurs interest? You're welcome, Lisa. Okay, something else I want to tell you about disclosure about this, the 1933 Act before I move to the next one. The last part says, in general, the registration forms call for disclosure of information such as a description of the registration of the registrant's properties and businesses, a description of the significant provisions of the security to be offered for sale and its relationship to the registrant's other capital securities, and information about the management of the registrant, and financial statements. So if you wanted to know about the finances of these companies that hold your securities, how much money they're making off of them, you could thank the 1933 Securities Act for that. Now we're going to talk about the Securities and Exchange Act, and I have a client to meet with in like 10 minutes, so I'm going to try to make this fast. All right, so the Securities Exchange Act of 1934. This act by Congress extended the disclosure doctrine of investors' protection to securities listed and registered for public trading on our national securities exchange. The enactment in August of 1964 of the Securities Act amendments of 1964 applied the disclosures and reporting provisions to equity securities of hundreds of companies traded over the counter. Companies which seek to have their securities listed and registered for public trading on such an exchange must file a registration application with the exchange and the commission. So the Securities Exchange Commission was there for birth. Um, the commissioner's rule prescribed the nature and content of the registration statements, including certified financial statements. These data are generally comparable to, but less extensive than, the disclosures required in the Securities Act registration statements. So, following the registration of their securities, such companies must file an annual and other periodic reports to keep current the information containing in the original filing. So, those are the 8K and the 10K forms. I'm not sure if y'all have ever heard of that, but companies have prospectus documents that are going to fully disclose everything that they are doing with your securities. That's for number one. They also have what is called a 8K and a 10K form, which are annual and quarterly income reporting. So all of the money that they're making from these securities and stuff, they're reporting it on the 8K and the 10K form. That's what that was talking about. Um, let's see. However, the reported information is available for. Oh, so people always ask me, where do I find this information? So since traded by and between public investors, whether involving listed or over-the-counter securities, involve transactions between holders of outstanding securities, there is no provision for dissemination of the report data to investors through use of a prospectus or similar medium. However, the reported information is available for public inspection both at the office of the commission and the exchanges. It is also used extensively by publishers of securities manuals, security advisory services, investment advisors, trust departments, brokers, dealers in securities, similar agencies, and others who obtain widespread dissemination. So basically, that's saying that you can find this information literally anywhere on the securitiesexchange.gov, on the company's website, like I just showed you on Verizon's website, and also a lot of other websites like S&P Global is a good one. Fitch Rating is another one. Like literally, I just go to Google or DuckDuckGo or whatever search engine I'm using, I just go there and type in current SEC filings for whoever the company is, and it'll be much easier to get the information like that. I am getting a call, y'all. I'm sorry, but I'm gonna have to pause y'all for a second.